All right, our last case of the morning, which I tried to call before, I will now call again. Dorian Roberts, individually and as trustee of the Dorian Roberts Trust versus Florida Insurance Guaranty Association. Case number 2022-2318. Counsel, are you ready to proceed?
Yes, Your Honor.
And you are?
Sanford Kinney on behalf of the appellant, Dorian Roberts.
All right. Mr. Kinney, how much time would you like to reserve for rebuttal?
5 minutes for rebuttal, Your Honor.
Please proceed.
Thank you. Good morning, Your Honors, and may it please the court. Sanford Kinney on behalf of the appellant, Dorian Roberts. It is well understood that trial courts cannot go beyond the four corners of a complaint when resolving a motion to dismiss. FIGA is asking this court to make an exception to that rule for pre-suit notice.
Mr. Kinney, before you get started, can you just give us a thumbnail? We've got people watching today that might be helpful. Just what we're here about today.
We're here on whether or not the trial court improperly went beyond the four corners of the complaint to review the pre-suit notice, which is required under Florida Statute 627-70152, which informs the insurance company that they are initiating litigation.
And what was the underlying event?
The underlying event was a standard roof damage claim to the house, and there was a dispute as to whether or not there was coverage for that loss. And so they sent a pre-suit notice after originally United Property and Casualty, and now FIGA has been substituted.
And thank you, Mr. Kinney, for that. You talked about the four corners rule, and I believe, perhaps, for the people that know, everyone in the courtroom would agree that there is a four corners rule, and that emanates from the Supreme Court of Florida and trickles down through all the DCAs. I don't know that that's terribly controversial. So it's your position on behalf of your client that the court didn't abide by the four corners rule here, correct?
That is correct, Your Honor.
By considering something that was not appended to the complaint was actually appended to the motion to dismiss.
That is exactly correct.
Now, in response to that, they say, well, this is not a classic motion to dismiss case, because this is more akin to a forum nonconvenes dismissal or a personal jurisdiction dismissal, or in my old world, a medical malpractice dismissal. So what do you do with that, where you would have evidence potentially presented at that hearing?
Well, to Your Honor's point, going back to the medical malpractice, the statute does specifically provide a requirement that in order to determine whether or not the pre-suit notice provisions in a medical malpractice suit have been satisfied, the trial court must hold an evidentiary hearing to ensure that those have been complied with, and the statute requires that. Here, there's no requirement that actually take place. The same is true in my colleague on the other side's answer brief on anti-SLAPP statutes. So
you're saying in those two situations, now the Med-Mal statute says dismiss. That was my point. But you're right. It does talk about evidence, and the anti-SLAPP statutes are the same way, or arguably the same way. But what about personal jurisdiction? Venetian salami, and the Venetian says, oh yeah, it's a battle of affidavits. Why would that analysis point not apply to this statute?
Simply because the legislature had the opportunity, just like in other statutory requirements, to put in a requirement that they're subject to either having to append the document to the complaint, and the legislature simply did not do that. There are a myriad of examples, and outside of, I'm not sure that it's really that different from other scenarios, such as if on any claim, if the statute of limitations were to potentially have been expired, you can still generally veer under 1.120 that all condition precedent have been satisfied. And under our rule, we're simply, really the crux of our argument boils down to.
Well, doesn't it come down to the type of hearing you're dealing with?
I mean,
Yes.
it seems to me, and if you have a hearing on a straight up motion to dismiss, you're right, and perhaps counsel would admit you're right. If it's just a motion, a failure to state a cause of action, motion to dismiss hearing, four corners of the complaint and any attachments. I mean, that is so recognized, I think, that everyone would agree with it. But what was this noticed at? How was this hearing noticed? Was it noticed as that, or was it noticed as something that also could include affidavits?
To your Honor's point, it was filed as a motion to dismiss or in the alternative, a motion for summary judgment. However, FIGA has now abandoned that argument.
And I saw that, and that has evaporated.
Correct.
So, but was there some notice that accompanied the motion saying, yes, this is just a standard motion to dismiss, motion for summary judgment hearing, or not?
To my knowledge, I don't believe there was anything that said it was standard or not standard. I mean, it was just a simple motion to dismiss or in the alternative, a motion for summary judgment.
How do we answer that question without a transcript? How do we know what actually went on at the hearing?
Without a transcript, the best you can do is look to the trial court's order to see what the logic was behind the reasoning. And the order specifically says that although the order was filed as a motion to dismiss was granted, it said nothing about the summary judgment. The court essentially it granted a motion to dismiss by applying the summary judgment standard because it considered the pre-suit notice that was only attached to the motion to dismiss. And admittedly, it was attached to the response, but lawyers in the nature of an alternative motion make alternative arguments. We objected to
And thanks for bringing that up, Mr. Kenny. And I hate this word, but I'm going to use it, waiver. How have you not waived that argument by virtue of advancing that in front of the trial court by making a response dealing with the actual notice? How is that not waived here?
The response did object to the fact that the pre-suit notice was not properly before the court on the motion to dismiss. It wasn't a single sentence in the response, and it's standard, but the trial counsel did object to the fact that the court could not consider on a motion to dismiss the pre-suit notice.
So baked into the response was,
Correct.
you shouldn't consider this, but if you do, even though we object,
Correct.
Here's our response. So you would say, and that may be a good enough thing, there's no waiver there, because you said it's our position that the Four Corners rule would not allow something appended to a motion to dismiss to be considered as a part of a motion to dismiss a complaint.
Correct. It would have to be styled. It's an affirmative defense, and that's what the Supreme Court held in Custer, case that we cited in our brief. If you're going to deny that a condition precedent has been satisfied, the proper mode for that is to assert it as an affirmative defense and state with specificity and particularity in a pleading, in an answer, and then you can resolve that on a motion for summary judgment or on a motion for judgment on the pleadings when the court can properly consider that pre-suit notice.
If we were to send it back, wouldn't it just be the same result? If the court's going to make the same determination?
Well, that kind of brings me to the second ultimate point is not necessarily unless either one, I don't believe we're outside of the statute of limitations for her to be able to remedy a pre-suit notice by sending one again. But it goes to whether or not the notice itself was sufficient, the legal determination that the court ultimately made by going beyond the Four Corners to look at that notice. It's our contention that the pre-suit notice is more than sufficient to, the purpose of the statute of the pre-suit notice in sub 3 is to put the insured on notice of the acts or omissions that are giving rise to the suit. And the statute specifically says that a denial of coverage in and of itself is sufficient to be the notice. Now, the document that you submit when you're filing these pre-suit notice with the state, there is a box that you can check to say denial of coverage. And in this case, we put trial counsel said underpayment, non-payment of claim. Could it be more specific? Yes, but all you have to do is state with specificity the act or omission. And here, United Property and Casualty had denied the claim, and now we were saying underpayment, non-payment, and for the purposes of the facts of this case, they are essentially the functional equivalent because United would have certainly been on notice and aware of the act or omission giving rise to the suit.
So was there payment? Was there payment?
I don't believe
Any
them.
payment?
They offered a settlement when we sent the pre-suit notice, but I don't believe on the record there was any payment at all. It was a straight denial of coverage.
No offer of payment prior to notice.
Oh, prior to notice, I believe there was potentially some offered, but I'm not sure how much it was, or I am not confident on the fact of that, Your Honor.
Yeah, thank you, Mr. Kenny. I would like to explore, maybe that's where both the questions are coming from my colleagues. Their argument is underpayment / non-payment is an oxymoron because how can you have underpayment suggests there was some payment, non-payment says no payment. So what do you do with that, the internal inconsistency with the notice?
Well, given the fact that it was a straight denial of the claim, to my understanding of reading the record, there was a denial of coverage letter. I do not recall if there was an offer prior to them just denying the claim, but it certainly was a denial of coverage. And underpayment, at the very least, underpayment is inclusive of non-payment. If you're not paying a claim, you're underpaying a claim. And the fact that when you say
I hear you. I went and looked at some definitions. I was curious, and most of the definitions, not all, suggest that when you underpay something, you have to pay something. It's just paying less than you should have. And if you were saying non-payment, that's a different paradigm from underpayment. And I think that's FIGA's argument.
Yes, Your Honor. But for the facts of this case on the record and the fact that the denial of the claim itself is a sufficient act or omission on its own, although the terminology in the pre-suit notice could have been arguably clear, because if underpayment was not there, I'm not sure we would be having the same dispute. Non-payment of claim is the equivalent of a denial of coverage. FIGA disputes that, but for the purposes of the facts of this record, I believe that they're the functional equivalent of each other. But the purpose of sub 3 is to inform the insurer of the act or omissions so that way they can comply with sub 4, so that way they know whether they can continue to deny coverage, to maybe reinvestigate and open coverage, to make a redetermination on the claim. And nothing in Ms. Roberts' notice would deprive United the ability to know what they have to do to comply with the rest of the statute. They're the ones who denied coverage. It was a straight denial. On the pre-suit notice, when they say underpayment, non-payment of claim, United's going to go back and look at their files, and I would find it difficult to believe that United would be sitting there scratching their head wondering, why are we being sued? It's clear if you're saying underpayment, non-payment, if you chop off that first word, it's much clearer, but at the end of the day, they know that they denied the claim, and they know that that's why they're being sued. And so we believe that under the facts of this case, that term is sufficient to state with specificity as required under sub 3 of that statute. Because
Given the fact they denied coverage, your position is they were fully on notice of precisely what we were talking about.
that's correct, Your Honor.
In other words, just because it could have been written more specifically, perhaps, or more to the insurance company's liking, it satisfied the obvious purpose of the notice, which I think the purpose is gleaned from the name, right? To put them on notice as to what it is that they did that led to this cause of action.
That's exactly right, Your Honor.
Okay.
The purpose of the statute is to prevent it's supposed to promote negotiation and not filing suit before you should. And in this case, there were some negotiations back and forth, and then they denied coverage, and then they sent that pre-suit notice with that, and also additionally attached in the notice, they provided estimates, which we noted in our brief were on both sides not proper. Everything attached to the notice itself is not contained within the record. However, it contains everything that United would have needed at the time to understand exactly what the denial of coverage was based on, because it included estimates, reports. They had all of that information, and they were attached there, and they would have received all of that.
Do you recall if the record reflects that after receiving Ms. Roberts' notice that the insurance company reiterated its denial?
They offered a settlement, I believe, of $5,000, and then that was denied, but that was, I believe, only to prevent a potential suit being filed, but I believe they did stand on ultimately the denial of coverage.
Okay.
FIGA now takes the position that the inclusion of the pre-suit demand in the disputed amounts under sub 3A, 5AB, FIGA is basically taking the position that the more information provided in the notice, to the point I just made, because we had included those things, that actually nullifies the pre-suit notice in and of itself as well. But ironically, FIGA makes the argument that additionally the information not required in the statute asserts that underpayment, non-payment does not communicate the nature of Robert's claim, what caused the damage, when it occurred, or how UPC's decision constituted a breach of the policy. Those are two wildly inconsistent. You're basically saying we had no notice because we didn't have all of these things that's not required in the statute, but then we provide documentation that's only required if it was a genuine underpayment without a denial, not a denial, but just there's a dispute as to the amount that they believe has been underpaid. You have to attach additional documents, being estimates, reports, items like that. So essentially by including those documents, they're saying that the pre-suit notice is invalid, but then they're claiming that they didn't have all this other information, like the nature of the claim, but they are the ones who denied the claim, and we've provided all the documentation that would have put them on the sufficient notice. And so they're kind of irreconcilable stances to take. I believe I'm into my rebuttal time, so absent any questions, I'll reserve the rest for rebuttal.
Thank you.
Thank you, Your Honors. May it please the Court. This is Jesse Dyer on behalf of Florida Insurance Guarantee Association, FIGA. I think it's important to emphasize, Your Honors, that FIGA has two independent bases that it argues for affirmance. The first is that the Four Corners rule, while well established, has exceptions. And I'll go ahead.
I beg to differ. I went back and read our case. I read the case it relied on about this. If it's a legal issue, you don't have to abide by the Four Corners rule. Well, one, that runs afoul of Supreme Court precedent. That's my first problem with it. Second, I'm not sure that older 50 CA case says what you're saying. It was a forum nonconvenience case. So unless I'm mistaken, I think the Four Corners rule is alive and well in Florida, and there are no exceptions to it. But help me understand why I'm wrong about that.
Well, in the Tepper case, Your Honor, which I think
Is the 50 CA case, which was a forum nonconvenience case.
right, but it sets forth a general rule, and that general rule is a trial court is not bound by the four corners of the complaint where the facts are undisputed and the motion to dismiss raises only a pure question of law.
And it cites to a case, actually another forum nonconvenience case. So I understand in a forum nonconvenience world where you have dueling affidavits, but I just don't know that stands for the proposition that the Supreme Court of Florida is wrong on their pronouncement in Santiago, for example, the Kennedy opinion in 2016, where Justice Kennedy said unequivocally the Four Corners rule is alive and well. So let me ask you that. If our precedent says one thing and the Supreme Court of Florida says something else, who do we follow?
The Florida Supreme Court.
All right. Thank you, Mr. Dyer.
Yeah.
But explain to me how Santiago and the long line of Supreme Court of Florida cases got it wrong. When they say that the Four Corners plus any attachments, we understand that attachments may necessitate further inquiry, but nothing about the motion to dismiss adding documents is ever considered in that line of cases. So is there a case that you know of where an item, a document is attached to a motion to dismiss, where an appellate court like ours has said the court could consider that as part of a Four Corners analysis?
The only one that I cite, Your Honor, is Metro v. Tepper. I do believe that Tepper has been cited repeatedly. I cannot give you a specific citation, but I do believe, I know that in my own practice, I've used it repeatedly, and it has not been limited in the context of venue or something like that. But Tepper has been repeatedly cited. I do acknowledge that I believe more recently, about 2 years ago, the Fourth District Court of Appeal criticized it. But other courts have cited it for the proposition that I'm arguing. And indeed, again, I don't recall the specific name, but there's a Fourth District Court of Appeal opinion that preceded the one that gives it criticism. So I do think that there is a long line of cases since Tepper that allows where the facts are undisputed and the motion raises purely a question of law. It's similar to an issue of waiver, you know,
But doesn't that bring us into sort of a Dodge City motif where anything goes? Anything you attach to a motion to dismiss is fair game. If it involves a legal issue. I mean, and aren't you opening Pandora's box in that situation?
I don't think so, Your Honor, but
I wrote an opinion, Summerlin. I think it was quoted in part, perhaps in the reply brief. And that involved this very thing. There was an attachment to the motion to dismiss. It was an employment case, and the pre-suit notice was attached, and the court unequivocally granted the motion to dismiss based on the pre-suit notice. And among other cases, we cited Justice Kennedy in Santiago saying, you just can't do that. Mm-hmm. So tell me why Summerlin was wrong.
Well, I would say that it wasn't. Was it a Fifth District Court of Appeal opinion?
It was
First District.
It was
right.
the first when I was on the first.
It just seems to me, as I look at the case law, that the Fifth District, that Tepper has been construed in subsequent opinions to allow for the proposition that I'm arguing. But I don't, if it's okay with you, Your Honor, want to spend too much time on this first argument, because I do believe I have a compelling argument.
And I want to hear that too, Mr. Dyer. I think we all do. But you would agree, if Santiago is the law of the state, that mm-hmm. four corners and attachments and that's it, that first argument fails.
Yes.
All right. May I ask one last question before we move on to the merits pertaining to the notice? Subsection 5 of the pertinent statute, which of course is 627-70152, requires dismissal, mandates dismissal if the notice requirements are not complied with, correct?
Yes, Your Honor.
So if a plaintiff did not and will not attach the notice to the complaint to demonstrate compliance with preconditions, could a trial judge ever dismiss the case as required by the statute? Would there be a vehicle for that?
Well, it would be circumventing, if the statute didn't allow, if the court couldn't go, if the court truly was confined by the four corners of the complaint, then it doesn't seem to me that there would be a way for the court to dismiss it. I suppose you could move for summary judgment.
But it says dismiss. The statute says dismiss.
Exactly.
It doesn't say interjudgment.
Yes.
It says dismiss.
Yes,
and of course, we all know that the four corners includes all attachments to the complaint, of course. But if a plaintiff chose not to, and why would you?
Mm-hmm.
If a plaintiff chose not to attach the notice, could it ever be dismissed? Would there be any mechanism by which a trial judge could dismiss it? I mean, your opposing counsel, very artfully, and it's inviting, says, look, raise it as an affirmative defense, the noncompliance with notice, raise it as an affirmative defense, move for judgment on the pleadings, with the notice then either being provided with the answer and the affirmative defenses of like that. There's an element to that that's inviting, but the statute requires dismissal. Other statutes may contemplate in their spheres of application things like summary judgment or dismissal, but this statute doesn't. This statute says the judge shall dismiss it. And I'm trying to grapple with what I think we all acknowledge is the operability of the four corners, and what do we do with that well-settled rule of law in light of the text of this particular statute to Ms. Roberts' claim.
And Your Honor, this really gets to the heart of our issue. The second argument is that the statute very clearly does contemplate that the court is not going to be limited to the four corners of the complaint.
And Mr. Dyer, Judge Sal makes a good point. So we have language saying dismiss. Doesn't that bring us into the realm of the question I asked Mr. Kinney of a forum non-convened situation or a personal jurisdiction situation where there is needfully something more than the four corners? And would that be your argument here, that there was something statutorily that was required that would go beyond the four corners of this plea?
Yes, Your Honor, that's what would make this different. And so it would be more like the ruling a trial court would make in a personal jurisdiction motion to dismiss or forum non-convenes where the court is not limited to the four corners of the complaint and ruling on a motion to dismiss. The statute, I don't think, conflicts with any rule of procedure either. So it does make clear that the court considers actual compliance. So it doesn't say that dismissal without prejudice is required if the claimant fails to allege compliance. And that's the Gundel case, which we rely on. The same kind of analysis was performed in the anti-SLAPP statute situation. So the statute is concerned with actual compliance, not whether sufficient allegations were made. And so that evinces the intent of the legislature that on a motion to dismiss, that the court is going to consider actual compliance. And it doesn't conflict with any rule of procedure. Roberts does not come out and outright say that the statute conflicts with the rule of procedure. I think the closest Roberts comes is citing the language of the rule. This is Rule of Procedure 1110, subsection D. It addresses affirmative defenses, and it says that affirmative defenses appearing on the face of the pleading may be asserted as grounds in a motion. And this isn't dealing with an affirmative defense. Roberts, in its reply brief...
So don't we, I mean, so in the question, what kind of hearing was this? Was this akin to a personal jurisdiction hearing, as you heard me ask Mr. Kinney, or was this just a straight up motion to dismiss four corners of the complaint here?
No, Your Honor, it was not a straight up. It was never identified as such. Of course, we don't have the transcript before us, but...
Isn't that fatal for Mr. Kinney's client? Because we don't know what was said
Yes, Your Honor.
at the hearing.
Yes.
So if it was argued, and only argued, the four corners of the complaint, then it's a pretty good point,
Right.
based on Santiago, but we don't have a transcript.
And the burden, Your Honor, of course, is on the appellant to provide an adequate record, and the court's decision is presumed correct. And so the burden is on the appellant to show that an error was made. But correct, Your Honor, there's nothing in the record that would show that the motion was only argued as a typical failure to state of claim subject to the four corners requirement. And there would be no reason that it would need to be argued that way, because again, the statute itself provides a basis for moving for dismissal. Again, the same reasoning was applied in the Second District Gundel case. So that was the basis for the dismissal is the statute, and the statute would enable the court to go beyond the four corners of where it just wouldn't be subject to that rule. Because the statute is the basis.
And back to Judge Sal's point, a wise plaintiff's attorney could avoid this every time. Conditions preceding can't be met. It's baked in the rule. We have complied with all conditions preceding, not attached to anything, and that's game, set, match on the four corners of the complaint, correct?
Yes, the purpose, Your Honor, of the statute would be utterly frustrated. And I would emphasize that it doesn't say summary judgment is appropriate. It says dismissal. And so if that's the mechanism that has to be used, then necessarily that the court is going to have to consider more than the four corners of the complaint and consider actual compliance. And like you say, the purpose of the statute would be frustrated if they could simply just circumvent that by not attaching the notice to the complaint. And this is not an affirmative defense. I think that is worth pointing out. Roberts, in the reply brief, attempts to characterize this condition precedent as the notice of intent as an affirmative defense. It is not an affirmative defense. An affirmative defense avoids liability. So this is, we are not.
Why would a condition preceding not be an affirmative defense? I hear you on the nature of this hearing, but in that you're saying, I agree with everything they have pleaded, but even assuming all that's true, they didn't meet a condition preceding. In the Med Mal world, that would be you didn't comply with 766-203. That would seem to me to be a condition preceding that you would plead affirmatively. It happens every day. So why wouldn't it be
Right.
an affirmative defense?
There's a separate rule that says that conditions precedent have to be alleged generally, and then it's on the defendant to specifically deny it. If that's all that happens, and the case law is clear on this, and there's a Fifth District Court of Appeal opinion, Palma v. J.P. Morgan, if that's all that happens and there's a specific denial, it doesn't become an affirmative defense. And in any event, it wouldn't be, again, an affirmative defense is an avoidance of liability. That's how it's defined. And when an argument is made that a failure to comply with the NOI statute has occurred, it doesn't result in an avoidance of liability. It just merely becomes a situation where
they have no claim.
there's a dismissal and then they can refile. So it's not saying, so this is important. Custer, which is the Florida Supreme Court opinion on which Roberts relies, in the reply brief, says that, and this is in the Fifth District Court of Appeal opinion in Palma, footnote 3, specifically addresses this and distinguishes the Custer opinion, why the condition precedent wasn't an affirmative defense. In Custer, the court said, where an argument is made that a condition precedent is necessary to trigger contractual duties, it generally is an affirmative defense. In Palma, this court, the Fifth District Court of Appeal, distinguished that and said that Custer was different because in that situation, the condition precedent, which dealt with the requirement to submit to an examination for PIP benefits, would have avoided liability. So there would have been no liability. The policy in Custer said, we are not liable to provide you benefits if you don't submit to an examination. And also, the Fifth District Court of Appeal pointed out that in Custer, the condition precedent was raised as an affirmative defense. So if you just specifically deny a general allegation that conditions precedent are satisfied, it doesn't automatically become an affirmative defense. If you put it in your affirmative defenses and allege it as such, then it does. But I think that's the important thing. I would say that for the very reasons stated in the Palma case, this condition precedent is not an affirmative defense. It doesn't avoid liability. Assuming a court accepts an argument that the condition precedent wasn't satisfied, all that happens is that the case is dismissed and then it can be recommenced once the statute is satisfied. I'll go ahead and just wrap that up. I do think that the statute in this case is the big difference. That is why the Four Corners rule does not apply in this case. It makes it a situation where it's more akin to a motion to dismiss. That's what we say on personal jurisdiction or foreign non-convenes. And for that reason, the court did not err. And I would like to point out again too that the kind of hearing has not been established in this case. There is no transcript, and there wasn't a notice of hearing in the record. Moving on to the last argument, I do believe, for the reasons stated in our answer brief, Your Honors, that the notice in question was totally generic, utterly devoid of specificity. The statute states that the notice must state with specificity all of the following information, and number 2 is the alleged acts or omissions of the insurer giving rise to the suit. To simply say non-payment, underpayment of claim doesn't mean anything. I suppose that could describe just about any action taken by an insurance company.
Well, you bring up a good point. Do you have any other claims involving Miss Roberts from Crestwood Avenue?
Sorry, Your Honor?
Do you have any other claims involved? Does your client have any other claims involving a Miss Roberts on Crestwood Avenue?
Probably. I mean, that's not, well, I mean,
You do.
well, sorry, not on Crestwood. That's not in the record, Your Honor.
So Dorian Roberts has more than one claim.
You know, I don't know, Your Honor. That's not in the record. To show that there
Well,
is
and,
one.
and perhaps I invited that. My question is this. I mean, is this fatally flawed, fatally non-specific, when it says underpayment, non-payment of claims, when it is viewed within the particular claimant, Dorian Roberts of Crestwood Avenue in Titusville, Florida? Is it lacking specificity such that your client is not able to be notified as to what they did wrong purportedly that led to the suit?
Your Honor, I think I understand your point, which is that why couldn't, after receiving the notice, to the extent there's ambiguity, just go ahead and search our records and determine what actually occurred here. What I suppose we could think, well, they must mean this because we denied coverage for these reasons. But I think the legislature by using the word specificity, I mean, they didn't want the insurance company, it seems to me, to have to go search its claim file and sort of piece it together to determine why it is that the claimant feels that we breached the policy. I think that the legislature wanted more, and that couldn't be more clearly made by the fact that they used the word specificity. And so I think that the legislature intended to have a situation where the insurer could look at the notice, not have to do its own research, and just determine basically what's going on. But that would be impossible with this notice. But that concludes, unless there's any more arguments, questions, that concludes my argument.
Thank you, Mr. Dyer.
Thank you.
Rebuttal, Mr. Kenny?
Thank you, Your Honor. May it please the court. I want to start specifically to what was just brought up. To Judge South's point, that is exactly our point, is that viewed in context, Dorian Roberts, pre-suit notice, attaching all of the information, they have everything they need to be properly put on notice with specificity of the act or omission giving rise to that suit. With the knowledge and the claim history in their file, they certainly have notice. Also, to your point, Judge Suit, although the statute does say the word dismissal, this very court has seen subsection 5 be effectuated on a motion to dismiss, and that was in Smith versus United Property and Casualty Insurance Company from this court in 2024, which I actually believe, Your Honor, Judge Wallace was on the panel for.
Did you say motion to dismiss or motion?
Oh, sorry, a motion for summary judgment. Yes, that one dealt with the retroactivity issue on the pre-suit notice provisions, but it did specifically, the trial court, when it determined that it could be applied retroactively, granted a motion for summary judgment dismissing the action for failure to comply with subsection 3. So subsection 5, dismissing the action, was granted on a motion for summary judgment. So the procedural mechanism versus the remedy of a dismissal, a motion for summary judgment can dismiss an action without it being an adjudication on the merits such that it's entering judgment.
In the situation you're speaking of, and I did do a jet tour through some of the federal cases last night, in federal district court after federal district court grants summary judgment and then dismisses the action, typically with prejudice. But so in the situation you're talking about here, the statute says without prejudice. So would the court grant summary judgment without prejudice? Is there such a thing?
Well, I was having this conversation with my firm. It does seem odd because you have no leave to amend. It's not without prejudice. I mean, it's effectively the same. But yes, I believe you can, because in Jones versus State Farm Mutual from the first DCA, and it was a malicious prosecution claim, but they distinguished that final summary judgment can constitute an adjudication on the merits or a bona fide termination of the proceedings only if the trial court considered the merits of the case rather than if a judgment was based on a technical or procedural factor. So,
And I know there's a lot of cases, I don't know that you cited them, where you can grant a summary judgment with leave to amend. But I know that's a different paradigm than granting a summary judgment without prejudice. That's
Right.
something I must confess I've never seen. But I'm trying to think if this was a summary judgment hearing and it resulted in a dismissal.
So I think to your point, Your Honor, I there is no transcript. You are right about that. However, it is clear it was styled. The motion was styled as motion for summary judgment or in the alternative, or dismissed in the alternative summary judgment. The trial court only granted the order on the motion to dismiss. Even if they had styled it and it was a motion for summary judgment hearing, the court had no ability to hear that because it failed to comply with 1.510. They had filed that motion, did not comply with the 40 days. The court could not have had a motion for summary
And
judgment.
they've conceded that, I believe.
So then the only thing they could have been contemplating is the motion to dismiss, because that's the only thing that was properly before the court. The motion for summary judgment never could have been there, never should have been there, and the court only granted the motion to dismiss. So any question as to whether or not the court could have ever properly considered it on the motion for summary judgment standard just falls flat, because as a matter of law under the rules of procedure, it could not have been so. It only could have been a motion to dismiss, which is how the court styled its order. So I think looking at the order itself, even without a transcript, is sufficient for this court to be able to say that they were only considering the motion to dismiss, which makes the four corners rule apply, and the court improperly went beyond the four corners when considering the pre-suit notice, and it's not fatal to our case for that exact reason, because the summary judgment could have never been before the court. And we would ask this court to reverse and remand and hold that the pre-suit notice provision can be effectuated on a motion for summary judgment and dismissing the action, and that it should be remanded for further proceedings.
Thank you, Mr. Kenny. Mr. Dyer, as I said when we started this morning, we were going to take some questions from the students that are with us. We also have a VIP, a celebrity with us, Judge Lambert, who is a VIP because he is a married